even the facility of anticipation, which is available to a person who has committed murder. So, merely because the provision is constitutionally valid, is it a sound provision? If you view the provisions of the Act pragmatically, then in practical life, should there be a provision like Section 80, even in case of trivial offence like 310, where the allegation is made day in and day out? Earlier there used to be 506, 294 under the IPC, and since 506 was non-deliverable in Madhya Pradesh, people were being harassed, and the Pradesh has now made 506 available. Likewise, a provision like Section 80 should not be there in relation to trivial offences like 310. This was my query. There should be some balance somewhere, so that courts are not able to take an extreme look at on the face of the allegation as made in the FIR. No offence under Section 310 is reflected. Thus, depriving the police of making an investigation and coming to a conclusion that the offence under 310 is reflected or it is not reflected. The same applies to an offence under Section 325.
Justice Ramaswamy will respond to that. And anybody else after Justice Ramaswamy?
I come from that society. You know, when I was appointed as judge of the Andhra Pradesh High Court, I was invited to a place where I studied for being felicitated. I went there. To my hearing, one of the illiterate persons was talking is a Mala judge. I come from the caste. He was mentioning my caste. He was not mentioning my status as a judge. Caste is more predominant. It is one of mindset. Therefore, calling by caste by the people is common. Therefore, merely because that was made an offence, because it's being repeated. So to prevent that, how far it can be prevented, that is a different matter. But to prevent that being stigmatized by caste name, offence has been created. Therefore, we cannot take it that it is a false report. As far as the authority of the witness is concerned, I have got another experience recently in September. We have conducted a public hearing, a jury consisting of myself, a retired judge of the Madras High Court, and 3 distinguished professors, and the former vice the chairperson of the National Women Commission, relating to the atrocities on Dalits in Tamil Nadu, in relation to the election to the panchayats where reservation was given, and elections are not being permitted to be conducted. And witnesses have come. We ask them to speak through mic so that all will hear it. They are afraid to speak, and we ask them why. They have seen the persons, the upper caste people came there, and they were sitting behind them, and they said, we can't speak in their presence, because the moment we go back, there will be backlash. Then we asked them to remove the microphones and ask them to come very near to the podium and speak to us, and they have spoken all the facts. Why I am referring is, when they are afraid to speak before the former Supreme Court judge, a former High Court judge and other distinguished persons, and when they are in the court, in their presence, how can we expect them to speak with confidence? That is what the special justice has to take note of it. And we, when we are considering the evidence, take this factor also into consideration. Naturally, being afraid of them, they may turn hostile. It is not an account of the fact they wanted to get some compensation, they played under the rules, and then get away. Therefore, this is a hard reality in life.
Sir, these are not the conditions prevailing in Madhya Pradesh.
Either way, not only Madhya Pradesh. As a member of the National Human Rights Commission and as the executive chairman of the National Legal Service Authority, I have gone through the entire country. It is prevailing everywhere in the country.
No. there are cases where...
Whether we are entering into appreciation of fact. Your appreciation of fact that a particular place may be like this.
No, but
so far this
I have a suggestion to make. In many enactments there is a provision that bail should be granted only if the judge is satisfied that offence has been committed. Why can't we introduce such a rider in section 80 while making provision for any offences?
Yes, I would like to intervene. The problem that Justice Ramaswamy has just alluded to, that when High Court judges, Supreme Court judges were there talking at the podium, yet those people were afraid to come forward and to disclose their problems. The answer then, what from this suggestion does seem to me, is not by simply making the legal system more tighter, but really having non-militant organizations in the areas who will represent the interests and having a wide pervasive system of legal aid. So it's not really tightening the law and having it implemented and having people who will support these people, who will give them comfort even after this podium of judges is gone or after the witness has given evidence in court. So that kind of thing is needed rather than just making the law tighter or having special provisions. In any case, I think that so far as tightening of the law is concerned, if you do give just some proper discretion to the judges, and there are some, again, like this particular group, HRLN, etc., if it intervenes in the High Courts, gives directions how these cases, what should be the appropriate punishment, assuming it was a common law, for the offences which are common, for which are also penal code offences, and that if we could have some seminal decisions, that would be another way. Rather than having separate law, but certainly for some areas which are not covered, we pointed out just now by Mr. Krishnan, various cases of atrocities, different kinds of atrocities which are not covered in penal code, you can certainly have a separate offence. This is the point I'm highlighting.
The statement and objects of the POA Act clearly brought out the distinction between the offences prevailing in the IPC and the offences which are being facilitated by those offences and need for the special law. It is true that when the law is made stringent, we as judges prone to be more cautious before proceeding in the finding whether the offence has been proved or not, or prima facie case has been established before granting bail, etc., etc. But the need to make special law was on account of the unabated perpetration of atrocities on the most vulnerable groups, namely Dalits and Adivasi.
Chairperson, I wanted to respond to what the question that you said. It's about section 3 to 310. We're saying that my name is Martin McQuan, I come from Gujarat, I've been activist for 25 years. I think this accusation of the law being misused, especially section 3110, I think the first point I want to make, in no case is a person who is the victim tells the police that to put this section. It is the police who applies that section. On the part of the victim, there is no knowledge that this section must be applied or not applied. We did a study in Gujarat. 98% of the cases are only recorded under section 3110. The police will insist that unless you bring it on record that you have been called by derogatory name, it does not become an offence. I think we must appreciate this reality that a lot of investigation is in the hands of the police, not in the hands of the victim who wants to say the story.
This is the point I had sought to make even in my presentation. The law defines the offence. It's ultimately the state which is defending the offender. So if 3110 is invoked, I would kindly request your attention to section 3. There are 15 subsections. And the subsections are very broad. They cover much more than calling a person by the name. But never are they invoked. If you look at it, section 3.1 of the 15 subsections, barring 3.1.10 and occasionally one or two of the others, most of the things have never been invoked. Although day in and day out you read in the papers that these things are happening. I mean, either we say that it is not happening, but
they are quite aware of the procedures. They are not all that ignorant.
I would like to add something here.
It's a matter of controversy.
I would like to add one thing here. Mr. Krishnan pointed out, rightly I think again, that in certain years UP, there was a massive registration of SC/ST Act cases, and then when the regime change came, they simply seemed to have vanished. To say that no, it's a legitimate exercise by the police, that they suddenly decide to institute SC/ST Act case and they don't do it on other occasions, I think that premise is a little questionable.
Sir, I'm Vincent Manohar from the National Campaign on Dalit Human Rights. See, we understand very clearly that special laws are there not only for addressing this caste issue. We are having special laws for addressing the issue of terrorism, for the issue of women, for the issue of child labor, for the issue of bonded labor, where also the laws have been misused or abused in certain pockets. But there is no demand from anywhere by saying that these laws should be taken away. But while it comes in terms of only the SC/ST Prevention of Atrocities Act. The other point is, Justice Ramasamy has already said about that Madurai incident where the people were not able to come to speak before others are sitting. Here another victim is sitting here, she is going to depose. Yesterday, she denied to appear before the media, saying that if I go back, already it was covered by NDT. When I go back, they will attack me. So we are not asking for anything to be a social behavior to be changed. When a section is there, when act is there, whether we are going to implement this just to make others to feel that if it is, again if they go on perpetrating it, then definitely they will be punished. That kind of an attitude that we should. Thank you.
I believe nobody has suggested for the repeal of the Act. Nobody has suggested. Judges have come across certain problems. They are discussing that. I don't think anyone of us suggested for repeal of the Act. That's everybody is concerned. That's the concern of the judges also. And judges are also human beings. They are concerned with them like anybody else, if not more than them.
I am Justice Goyal from Punjab High Court. I have also been dealing with these cases, and I share the points which have been made by my brother Justice Kulsheshta from Madhya Pradesh High Court. The problem is not with the Act. What happens is we are dealing with investigating agencies who do not act honestly always. They will, at the instance of interested parties, institute such cases where people can be harassed or arrested. Then they will choose out of those offences where bail will be denied. They will institute a false case either under SC Act or under NDPS Act or under 376, which are most heinous. Why those cases mostly result in acquittal? Or why what we feel is, on the one hand, we are convinced that the person is innocent. What do we do? Therefore, we have no quarrel with the Act or protection of the Dalits at all. We want justice to them. At the same time, when we are faced with a situation, we had in our High Court a complaint against a sitting district judge, a false complaint of rape. Ultimately, that complaint was withdrawn, and we were going to suspend the district judge. We made inquiries, we found the complaint is false. Thereafter, the complaint was withdrawn. We have ladies available who can be made instrument by being bribed to file a 376 case. No rape has actually taken place. We have some people, vulnerable people, available who can be bribed to make a case under SC Act. No atrocities have actually taken place, but still there is a victim. If we deny bail and put them in custody, we are only encouraging innocence. That's the dilemma which I share with my brother Justice Dixit.
The judge explains incidents which happens everywhere, and therefore it can't be judged on that basis. One may come across an incident in which you believe it's absolutely a false allegation. The others who are working may believe that these are strange incidents, and therefore we can't come to a conclusion.
Large scale.
Yeah, that's a matter of perception, brother. That's the matter of perception. You believe that large number of cases. Only recently we have read in I think the Delhi High Court or some High Court said that atrocities on women, the 498A cases, are majority of them are false. Actually, it's the judges what you call the gut feeling, or the you believe it's a false. But the person who has suffered, we are making this a statement. In many of the cases, we have found this statement. 498 cases, 90% of them are false. It varies from the state to state. As Brother Kushest was saying, that so far as Madhya Pradesh is concerned, I was judge in Madhya Pradesh for 7 years before I was elevated, I was transferred, and I came back to my own court. I share with him that so far as the Madhya Pradesh is concerned, maybe stray cases I do not know, but they know what is the Schedule Caste and Schedule Tribe Atrocities Act, and cases are registered. Actually, the state, and during some period, one period, there was a large number of cases. At that time, the state decided to grant compensation of 50,000 or something like that. I do not know. I tell you very frankly, honestly, I do not know what's the truth. But after that decision of the state government comes, and a large number of cases are instituted, then can it be said that it was just a coincidence? I am not taking this stand or that stand. But there are certain things which happen which agitates our mind and becomes very difficult. I tell you, all these discussions, we have started with that, we are ending with that. Because we are facing these problems, and these problems will go on so long these problems subsist. Now, my brother Mishra wanted to say something.
I may not be misunderstood, because we are all for this act. It should remain. But at the same time, I am happy when Mr. Suresh was speaking, Justice Ponaiya spoke, that they at least left out the cities for the time being, that this discrimination is rampant in villages. When we go to this distinction, probably time has come to assess whether we have economic distributed justice has reached to the villages under Article 39 BC. What is the root cause? In villages, whether the caste system is responsible. Villages, there are humans. City, there are human. Indian caste is one. System is one in cities and villages. What is that responsible in the villages which is the pricking cause? Wherefore we see that this observation, whether it is based on hygiene or some other economic factor or other distributive factor or landlessness, where we have failed. Time has come to assess not only for judicial system, political system, judicial system, both have to work in tandem. Because it is the constitutional aspect which we are discussing over here. We may not amend the law. It is for the government to amend the law. But time has come where we have to ponder whether there should be ever-widening horizon of this inclusion of scheduled caste into that. Supreme Court had to come down heavily in Millen's case. You cannot do it. The states are doing it just to oblige few persons, few societies, because this we cannot get rid of, because this is not caste system. This is intermingling with the political will to capture the votes also. What is being done politically has to be undone by the judicial system also, as has been done in Millen's case, the state of Maharashtra versus Millen's case. Because the state were ever obliging to include all those castes and to give them a cover, which is actually not existing. This caste system is not existing in our country by itself. So time has come to ponder over the root causes. Until unless we go to the root causes and prevail, I agree that there are certain castes, I do not name any caste. There are certain castes which may be oppressive. But what is that reason why that caste is allowed to remain oppressive? What has not reached to that other part, which is essential, on which entire focus has to be made by us.
Point well taken, brother. Now we get to the end of this. Actually, to chair this session was a surprise to me. I was not to chair this. As I said to you, because I was the first few persons to arrive in the morning.
I am Justice Yo from...
It's the same topic. The next session, we will take a question.
No question. I just wanted to say, just less than 30 seconds.
Please.
Sir, I have heard all my brothers, members. What I think that it is mental pollution which is the root cause of everything, and unless we remove that mental pollution by social awakening and creating social compulsions in those areas where these kind of atrocities are there. Because it may be atrocity in village against the so-called Dalits or Schedule Caste. But in big cities also we find that there are dons who are Thakurs dominating Pandits, Pandits dominating over Banyas or the Thakurs. So this is a mixed kind of thing going on. So that's my suggestion that please let us go to the root cause, that is the mental pollution and social compulsion. Why in cities atrocities are less? Social compulsion is this, that if I don't get a higher caste person to cook my food, I am ready to have a lower caste cook also and telling him don't tell your caste. So it's the social compulsion. Thank you.
Point well taken. I repeat, it came as a surprise, but I enjoyed it every minute. Thank you very much.
As you will notice, the topics for the afternoon, for now and for the afternoon, will cover many of the areas, and the controversy, in fact, will be heightened by some of the presentations made on the studies of Andhra Pradesh and so on. We are running a little late, but I think it is a much better session than yesterday in the sense that the participants have been able to speak. And any honourable judge who feels that he's not been allowed to speak for shortage of time, you will get chances right now and right after lunch as well. You structured the speeches so that will be 15 minutes. Yes, sir. Yes, sir. In fact, sir, yesterday, yes. In fact, sir, yesterday we were criticized because some of the speakers went on for about 45 minutes, and we were very strongly criticized for that. So as you can make out, we are being much later today. Justice Talukta, sir, you can please come. Any minutes.
Paucity of time, let me first introduce you to the first speaker, Professor Ravi Varma Kumar. He was the first chairman of Karnataka State Commission for Backward Classes, and he is a senior advocate of the Karnataka High Court and a professor of law. His areas of specialization include affirmative action, social justice, reservation of human rights, constitutional law, public interest litigation, legal literacy, election law, and law on education. He is also a human rights activist for his association with People Union for Civil Liberties, which you are all very well acquainted with. Now over to Professor Varma.
Thank you, sir. Respected Chair, distinguished judges, past and present, and my friends. At the outset, I heartily congratulate Human Rights Law Network as well as the National Human Rights Commission for organizing this colloquium, which is first of its kind. I am particularly happy that for the first time a judicial colloquium is discussing such a vital issue, plaguing the country for almost thousands of years, and a vast number, over 300 million victims of untouchablity. So it gives me great pleasure, and I deem it a honor to be amidst you and to have a few words so that we can interact later.
I've been asked to speak for only 15 minutes, so I'm reducing my listening. I'm not going to make a full presentation as it was originally thought of. Most of you have already been furnished with a copy of the report, so there is really no need for me to go through all the chapters, be that as it may. Before I tell you something about the report, I request you to kindly recollect a case that was decided by the American Supreme Court way back in the year 1954. The case is Brown versus Board of Education. As early as in 1954, after reversing a case which had held the field for several decades in Plessy versus Ferguson, where the theory separate but equal was accepted by the American judiciary as equality, the Supreme Court of America went on to say separate is inherently unequal, and therefore the moment it is separate, it cannot be termed as equal. This they said in a case where they were considering the existence of separate townships for blacks and whites. A district judge had ordered what is popularly known as busing, to take the students from white township to schools in black township, students from black township to schools in students from black township to schools in white township. Upholding this order, the district judge, the American Supreme Court, for the first time gave this historic verdict, upheld this principle of busing. As you are all aware, the American Constitution is colorful. It doesn't provide for any kind of a policy, program or a legislation to be made similar to what we find under the Indian Constitution. And even in a color-blind Constitution, the Supreme Court of America rose to the occasion and provided for this, and that has now become the foundation for dismantling segregation in America in a very big way. So it was not the legislature, it was not the executive, it was the American Supreme Court which showed the way through this case to dismantle segregation. Now India was at the forefront of the agitation against apartheid in South Africa. While doing so, we always said any practice of apartheid is inhuman, and therefore we fought against it. Under the Indian Constitution, we have incorporated a whole lot of policies, programs which are aimed at achieving this. I'll just read one provision. Hotels and places of public entertainment, or the use of wells, tanks, bathing gardens, roads and places of public resort maintained wholly or partly out of state funds or dedicated to the use of the general public. Now this is a clear injunction against any segregation. Now keeping this in mind, since we have judicial statesmen, leaders from the judiciary, from a judiciary which yesterday Justice Suraj Patil very rightly said we should be proud of, and internationally we are recognized to be a proud judiciary. Now we have taken any number of initiatives by way of judicial activism. Why has India not produced one judgment comparable to Brown versus Board of Education? It makes me very sad because Mr. P.S. Krishnan was just now telling you 80% of these untouchables live in villages. We have 6.5 villages. To these 6.5 villages are attached satellite hamlets, which Baba Saheb Ambedkar termed as concentration camps. They are all ethnic hamlets. These bastis, they are not even full-fledged villages. In my own state, Karnataka, there are 29,000 villages to which 30,000 hamlets are attached. All the Dalits, all the Adivasis, they live in these 30,000 hamlets. Even to this day, 55 years after the Constitution abolished untouchability, we keep them separate. We deny them entry to the village. We don't provide residence in the village. And this goes to the root of the problem we are discussing today. Because Article 17 said we should abolish untouchability. We have abolished untouchability. Have we really abolished untouchability? We have not dismantled one such hamlet which is an ethnic segregation. What is apartheid after all? It's a Dutch word which says aparthood or living apart. So all these hamlets that exist, all these bastis, hattis, keris, hadis, pawars, they're all these ethnic segregations which are wholly unconstitutional, and we have permitted them to exist so that freely untouchability continues to exist. So this is one area we have not been able to dismantle the units of apartheid or segregation. And secondly, the social units. The Constitution has provided a wonderful program to dismantle the social hierarchy, to dismantle the ascending order of reverence and the descending order of contempt. We have 5,000 castes. All the 5,000 castes are arranged one over the other. No two castes have the same rank. They differ in status. Birth in a caste defines my occupation, my social status, my educational rights, and even my residence. And as one speaker put it in the morning, as to where I should be buried. Caste is defining our life from cradle to grave and even beyond the grave, because we can't be buried in graves which are not specifically available for the Dalits. When such is the situation, this is the challenge before the judiciary to make the provisions of the Constitution, a fundamental right under Article 17, meaningful. And I look forward for the judiciary to rise to the occasion and to take the necessary initiative to dismantle this apartheid, dismantle this caste system. The ways and means of doing it can be definitely discussed. We have no time. For example, one of the ways could be in ensuring that intercaste marriages are promoted. NHRC report, to which I am going to refer, has documented the various states where such measures are already initiated. But what is initiated is a very small step, not in a big way. we have not really taken any bold step to dismantle the caste system. On the other hand, we have been promoting caste system in a very big way. Particularly, it has now become a habit that every institution is sanctioned to a governing body which belongs to a caste or a community. In Karnataka, all the 29 colleges, private colleges, medical colleges are managed by organized caste organizations belonging to this or that community. So therefore, I appeal to the judiciary to rise to the occasion and to take up this aspect, because in India, unless you destroy caste system, annihilation of caste doesn't take place. We are not going to have equality. And therefore, that is the biggest challenge before the judiciary today. Now with this preface, since you already have the report with you, the NHRC report, broadly, if I may say so, the report has about 10 sections. Of the 10 sections, the first section deals with violence and the cause of violence, namely the caste system. It goes deep into the subject as to the very genesis of caste system, the contributions of the reformers and poets like Kabir, Nanak, Ravidas. It has documented the impact of Muslim rule, the British rule, and the introduction of the concept of rule of law, and goes on to lament that the caste system continues to exist without any let or hindrance. The second section deals with the constitutional commitment to equality, the strategy and approach, and the 3 sections: provisions aimed at protecting the Dalits, then the provisions aimed at compensatory discrimination, and the third, the provisions aimed at development of these sections. In this, it has referred to the various enactments, including the enactments we have been discussing from morning, namely the Protection of Civil Rights Act, Prevention of Atrocities Act, then the Employment of Manual Scavenging and Construction of Dry Latrines Prohibition Act of 1993, abolition of the Devadasi system. As you are all aware, the most evil practice, most inhuman practice, which had a religious sanction, is to dedicate girls to prostitution in the name of God. In Karnataka and Andhra Pradesh, it was happening in a very big way. It is known as Devadasi system. We have now 2 legislations in these 2 states which have prohibited the practice of Devadasi system. That is referred to in this section. Then the Bonded Labour System Abolition Act of 1976, the Minimum Wages Act of 1948, Equal Remuneration Act of 1976, Child Labour Prohibition and Regulation Act of 1986, Interstate Migration of Workers and Regulation of Employment and Conditions of Service Act 1979, and the various land reforms legislations and debt relief legislations are discussed in this section. The third section deals with social justice, where a more elaborate treatment is given to the concepts under the Constitution. The constitutional provisions are discussed threadbare. The economic safeguards, the educational and cultural rights, the political safeguards, and the service safeguards are discussed. More importantly, this section very interestingly documents all the institutions that are created, the entire watchdog machinery that is created under the Constitution to monitor the implementation of these legislations. Then the fourth section deals with protection given to the Dalits and the working of the two enactments, the PCR Act and the Prevention of Atrocities Act. Mr. Krishnan has already given you the details of several aspects which are reflected in this report also. The number of cases registered, the prosecutions, the number of prosecutions that end in conviction, and the number of prosecutions that end in acquittal, all those things are discussed here. And very importantly, this gives a very comprehensive picture of all the measures that are taken by the various state governments. Yes, I'll conclude in 5 minutes. All the measures taken under the by the various state governments, it is very well documented. Then the fifth chapter deals with the aspect of protection, in as much as it has failed to protect the Dalits and Adivasis. Here, there is a very good auditing of the working of the various watchdog institutions, the Schedule Caste Commission, the National Schedule Caste Commission, National Schedule Tribes Commission, the Human Rights Commission, the National Women Commission, the National Safai Karmachari Commission. All those commissions are discussed in the fifth section. Then the sixth section deals with locating the responsibilities. Obviously, the blame is squarely put on the state, especially the police and the executive. Very interesting findings recorded by non-official bodies. For example, Sakshi, whose publication Justice Ramaswamy just now released, have all been documented here. And more importantly, the role of the judiciary also has come in for auditing in a very big way through the reports submitted by these non-official bodies. It makes a very interesting reading. I think all the judges will bear the aspects mentioned there while dealing with these sensitive issues belonging to this area of concern. The seventh chapter deals with compensatory discrimination, with which the courts are familiar, right from Champakam Rajan to the latest case in Badapanawar. The Supreme Court has been grappling with this issue in a very big way. Yesterday we discussed Indrasani case, and I want to just place one fact which was also discussed shortly. There cannot be any comparison between the concept of reservation in favor of Schedule Caste and Schedule Tribes with that of the affirmative action in favor of the disabled persons. The object of reservation is only one. The object of reservation is to achieve adequate representation to the Schedule Caste, Schedule Tribes and backward classes. It is not a poverty alleviation program. It is not a program for removal of unemployment. It is not a illiteracy removal program. So therefore, this is only a small step, a small but a sure guarantee that there shall be representation in all walks of life. As against this, the reservation, as against this, the reservation provided in favor of the disabled persons is not intended to provide for any representation to them in the services, but recognition of equal right in them, and therefore to honor their equal right, they are given a right to be selected. Only for that limited purpose, the reservation is given. So this is one aspect on which I wanted to say this, and since time is running out, other chapters I am not going to. Only one aspect. Though this is termed as NHR's report, the report is not actually produced by the Human Rights Commission. It is Mr. Saxena, an IAS officer retired. He has produced it. In fact, I'm really worried about this aspect of the matter, that such a major issue, the NHRC itself has not produced. This is an area of very big concern. It should be immediately addressed, and the NHRC itself should come out with an authoritative report documenting all aspects of the matter. Be that as it may, the report has one small shortcoming, though otherwise it's a very comprehensive document. That is, it has not noticed the need for a representative institution in all walks of life. Yesterday, for example, a question was asked, can the judiciary be an island in a society with such widespread prejudices against disabled persons?
Professor Verma, your time is up, please.
In that direction, the Constitutional Review Committee has said the extent of reservation provided, it is abysmally low, next to nothing, and therefore the need for ensuring that there is enough reflection of the social composition of the society. In this behalf, I will close it with only one comment. I had the privilege to participate in South Africans preparing the draft constitution in the year 1991. When the African National Congress was about to come to power, they started preparing themselves to come to power and to enact a constitution for themselves. At that point of time, I had the unique privilege to participate. I was invited by the African National Congress Constitutional Committee, and a suggestion made there has now found a place in the South African Constitution. Section 174(2) of the South African Constitution provides for not a quota or a reservation. It says the composition of the courts, including the Constitutional Court of South Africa, shall be reflective of the gender and racial composition of the South African society.
Thank you very much.
That should lead us, give us the light to ensure that our judiciary also becomes representative. Thank you.
Thank you very much, Professor Ravi Verma, for your illuminating speech. Now, gentlemen, we have before us a very eminent speaker, Professor Shubhdev Thorat, who is a professor of economics in the Jawaharlal Nehru University and a visiting professor of Iowa State University, USA. And he is also a champion in the cause for Dalits in various fields, and he is a winner of Dr. Ambedkar Chetana Award. Now, Professor Thorat.
Before the Mr. Chairman, excuse me, Chairman. Excuse me. This side. Before commencement of the lecture, we would like to make one request to the honourable speakers.
Yes.
So, most of us are aware of the problems. What and the law and the existing law. We wish to know more about how the laws are being implemented. On account of implementation of the law, what was the reduction of these atrocities against the Dalits, and what was the feedback, if any, collected by any organizations?
Yes, brother, after Professor
to enable us to know whether any change needed in the legislations, or whether there are any problems in the implementation. That would be...
Brother, after Professor Thorat finishes, we'll have the interactive session. Definitely we'll deal with this matter.
Mr. Chairperson and distinguished guests, I am not from Iowa State University. I am a professor of economics at JNU and currently a director of Indian Institute of Dalit Study, which has been recently set up. Since given the limited time, I am asked to speak on the right to food and discrimination faced by the Dalit, particularly in having access to the different schemes which are related to food as such. But before I do that, let me open up by saying that there was a discussion at the beginning that what are the sources of discrimination, and there were viewpoints that came from some people, and some of them might be surprised as to why the right to food issue is figuring in the discussion here. One is to recognize, I think, and this is not necessary to repeat it again, but one has to recognize that the caste system a social organization of ours, of Hindus, which has a foundation in religion. The caste system divides people into different groups, allocate rights in an unequal and hierarchical manner, gives more to some and none to others, like untouchable. But what is more important is that it provides a mechanism for enforcement, a societal mechanism for enforcement in the form of social ostracism and penalties. So what atrocity that we are discussing about is nothing but a faithful implementation of those provisions by the people in the rural areas. If the people are willing to kill their own daughter for getting married for the untouchable boy, you have to raise question. People are not wrong. What is wrong is the social system and religion that they are following. So you must understand the roots of the problem of caste system are not in psyche. They are in the social organization which has a religious root. Therefore, in USA, you had a law against slavery and slavery disappeared within 10 years. We have a law against untouchability and untouchability still persists after 50 years simply because it is a religious institution. And that you must understand. And therefore, it covers wide relationship. You take any aspect of social life of Hindu, he will practice untouchability, he will practice discrimination, because that is how his social system is. And therefore, if we talk about food, right to food and access to food, you should not be surprised that there is a discrimination. And in fact, I would submit you as a lawyer and as a distinguished people who enforce the law, that you require more laws to cover as many social aspects of Hindu society where discrimination practice. In fact, the existing law is incapable of covering various dimensions and aspects of discrimination that untouchable face. Because it's a living mode exclusion and discrimination. It is not 1, 2 or 3 sphere. It is everywhere. Because that is how the society is, that is how the religion is. Now, after this preliminary comment, let me come to the issue that Collins really wanted me to share with you, that what are the problems discrimination faced by the untouchable. And it's a challenge for you that these are the area which doesn't appear in your cases quite often, but the discrimination exists and you should think over it, how do you be under the implementation of the law. There are several areas. Untouchable do not have access to restaurant. There are studies by Sakshi, by Surgeon, by Action Aid. I do that work. Review the untouchability study. There is a lack of access to restaurant. There is a separate arrangement. There is a discrimination in selling meal by the untouchables by the scavenger. There is a discrimination in selling vegetable by the scavenger. Nobody buys from them. So they fall back upon their traditional scavenging occupation. So there are several areas where access of food and consumption is restricted because of the caste discrimination. But I am going to share with you within 2 minutes or 5 minutes finding of some of the studies where earlier we did not know about the discrimination. This is a study that the Indian Institute of Dalit Studies has conducted, and the field work was done by National Campaign on Dalit Human Rights. In fact, it is Colin who made a suggestion that this study is necessary, and I want to share with you that there are a number of schemes which government has. We don't have a law, strictly speaking, of prohibiting caste discrimination in the private domain. But at this public domain, we have these 2 laws, Anti-Untouchability Act and Prevention of Atrocities Act. And there are several public areas where untouchable have a legitimate access. And I have picked up only 2 midday meal schemes. You know, you are familiar with these midday meal schemes, that where the boys are given meal in the school during lunchtime, and everybody is supposed to have an equal access. Then you have PDS, fair price shop, where everybody is supposed to have access to food with a minimum fair price shop. I have taken these 2 schemes, and you see the dimension of discrimination that the untouchable face here, and think for yourself how you can expect the law to cover this kind of relations. 550 villages surveys for 5 states: UP, Bihar, Madhya Pradesh, Tamil Nadu, and Andhra Pradesh. What do they discover? That at least in 2% of the villages, a very small proportion, the untouchable boys were not allowed to have a meal in the school. Outright exclusion from having access to the meal in the school. That is one form of discrimination. But if you take other forms of discrimination, then what you discover is this. Is there a caste discrimination? There is. Questions were asked to about 550 in villages to the untouchable, and they tell that in 37% of the villages, they say yes, discrimination is practiced in the midday meal scheme. Rajasthan topped the list with 54%, followed by Tamil Nadu 36%, and Andhra Pradesh comes at the bottom. What are the forms of discrimination that are being faced by the untouchable children while operating the midday meal scheme? In 31% of the cases, they are asked to sit separately. In 9% of cases, separate meal is altogether served for them. In 48% of the cases, untouchable cooks and helpers are not allowed altogether. Half of the cases, their untouchable cooks are not allowed. There is a crisis in Uttar Pradesh now that the moment Uttar Pradesh government started the cooking, earlier they were giving dry rations, now they are cooking. No untouchable cook and helpers is allowed. The DAC, which is one of the organizations, asked me to conduct this study. In 9% of the cases, inferior food is given to the untouchable boys. And there are other reasons. These are the forms of exclusion and discrimination. Have you ever seen this case coming before you? So you need laws, you need regulations which will cover wider framework of discrimination as such. In Rajasthan, there are 55,000 of cook and helpers are appointed to run the meal scheme. John Ray's study suggests that in 60% of the cases, untouchable cooks are not allowed. So there is exclusion from employment, there is a discrimination in employment. Please do cover in our law if you can cover. Let me come to the PDS. I am not going into detail because we don't have time, but I will take the questions if you have. Public fair price system where every untouchable in a village should have an access to buy the food at a given price. But what we find, if you look at the ownership of this fair price shop, these are almost 80% of them are owned by high caste. And in almost 70% of the cases, these shops are located in the high caste locality. These two factors make the Dalit and untouchable so much susceptible that they face discrimination, even acquiring this normal right of buying food from the PDS shop. Let me give you a statistic. The practice of discrimination, a general question was asked to these people that do you experience the discrimination? In Andhra they say 17% of respondents say, the villages say yes. In Tamil Nadu 41%, in Rajasthan 42%, in UP 54% and Bihar 86%. By discrimination being faced by the untouchable in acquiring food from the PDS. What is the form of discrimination? I have classified them into 5 categories. Discrimination in quantity. They are given less than what is given to the high class person. 40% cases. Discrimination in prices, 28% cases. The untouchables are charged a relatively higher price for the same food as compared to the high caste. In 48% cases, dealers favor their own caste people in various ways. Giving them food first, asking untouchable to have a separate line, various kind of things. Dealer practice untouchability in 26% cases. What is the kind of untouchability? In Bihar, when the musher comes to buy, a cloth is hanged because to see a musher is something which is inauspicious. Various forms of untouchability as formed. Now, that is why I made my opening statement that the discrimination is a social phenomenon, practiced on a wider scale and day-to-day basis in all aspects of life. It is a challenge for you people. How do we cover? In any case, Manusmriti's provisions were customary law, you must understand that, which cover every aspect of the social life. And that we have to overturn. We have tried to overturn through constitutional provision and Anti-Untouchability Act. What I will submit briefly is that the right to food and access to food, which is the right of everybody, you see a discriminatory act simply because they belong to a particular section. And in the public domain, forget about the private domain, we do not know what happens in private domain. We do not cover caste discrimination in private domain. But this is the public domain where everybody should have an equal rights as such. And there are a large number of studies. Actually, conducted a study of about 500 villages, which we are bringing out a book on untouchability based on that. We have conducted a study in our own institute, and there are many studies by Sakshi and now Surgeon and many NGOs. They will tell you that in many areas where the question of access to food comes in, they face a considerable amount of discrimination. I think I'll stop here. As far as your question is concerned, sir, that what are the provisions, I think it is for you to see, in my view. You are the best judges. You should change your law as to how we can bring wider forms of discrimination under your purview. Thank you very much.
Thank you, Professor Chonan, for such a lively brothers. If any interaction on this point, your floor is open to you, please. Yes.
I want to put one question to
please.
Professor Verma. You have said that they should be given sheltered appointment. They should be given protection in appointment. They should be given reservation. Now, there is also an experience that when people they get appointment, they start shunning their own people, and they become a class by themselves. Like in the case of the apartheid in the United States, where they were given American citizenship and they were treated on par. Certain blacks, Negroes, they started practicing discrimination against their own people. So how is it that they are forming a class apart from their own people, and how to obviate this discrimination?
This is quite a popular question. The human tendency is such, if you go to a DTC bus stop, you will notice it. Everyone standing in the bus stop will try to get into the bus the moment the bus comes. And once he is in the bus, he tries to push back others, saying that, "No, there is no seat, please don't come." The same man who was asking for a seat, the moment he gets into the bus, this is a tendency, human tendency, common to Brahmins and Bastis. This is nothing specific to Schedule Caste or Schedule Tribes. That is not a deficiency or shortcoming in the reservation policy. The reservation policy is to give representation to the extent legitimately due, proportionate to their population. The fact that one or two of them have behaved like that is not a matter which should find fault with the policy of reservation itself.
No, but don't you think that it is getting concentrated into the hands of few, and the benefit is not flowing to others?
No, I think this is not an observation made by you based on facts. It's completely wrong. There is a stereotype among those who look at the reservation policy that it is benefited to the relatively few selected section. No, that's not true. Out of the 13 lakh government employees, 60% of the class 3 and class 4 who comes from the poor background. So this is a stereotype that the relatively better off scheduled castes are being benefited. I think one has to look that it is benefiting the poor.
So would you not suggest in the context of these facts